Have you ever stopped to think about how the stuff sitting on your desk right now actually got there? Every single day, millions of tons of cargo and billions of dollars are crisscrossing our oceans and skies. It literally keeps our entire world running. But, how does all of this happen safely? How do complete strangers sitting in completely different countries actually trust each other enough to trade on such a massive scale? Well, in this explainer, we are going to completely demystify the fascinating legal and logistical frameworks that make this possible. We're talking about a hidden world of century-old rules, really clever contracts, and absolutely precise paperwork that moves money and goods across borders. Let's get right into it.
Here is our roadmap for the explainer today. We're going to cover the universal language of trade, choosing between FOB and CIF, financing global transactions, navigating carriage by sea, essential shipping paperwork, and finally, taking to the skies. Starting right at the top with Section 1, the universal language of trade. To really understand this chronological journey, we have to solve the absolute biggest, most immediate problem of global commerce, and that is misunderstandings between buyers and sellers. I mean, imagine you're buying a huge, expensive piece of machinery from halfway across the world. What happens if your definition of delivery is totally different from the seller's definition? It would be a complete legal disaster, right? So, to fix this, businesses use special trade terms. But because these terms can still mean slightly different things depending on what country you're in, the International Chamber of Commerce actually stepped in. They published a set of standardized terms that have a universal, globally accepted meaning. We call these Incoterms. By just dropping one of these Incoterms into a contract, both the buyer and the seller instantly know exactly who is responsible for what. It's brilliant. It completely avoids costly misunderstandings and promotes uniformity all over the globe. Honestly, Incoterms are the crucial foundation of this entire global system. Moving right along to Section 2, choosing FOD versus CIF. So, now that we have a shared language with our Incoterms, let's look at the two biggest acronyms you're going to encounter. These are the two main types of contracts used in the international sale of goods, and honestly, understanding them is totally vital for anyone buying or selling across borders. As you can see, our contract options cleanly split into two distinct paths that dictate exactly who bears the risk and responsibility. On one side, we have FOB, which stands for free on board, and on the other, we have CIF, meaning cost, insurance, and freight. Let's break down exactly how these two differ. In an FOB contract, the cost of physically putting the goods on board the ship is entirely on the seller. The seller completes their delivery the exact second those goods are loaded onto the ship. And crucially, that is also the exact moment the property in the goods passes to the buyer. From then on, if you're the buyer, you have to bear the heavy costs of the freight and the insurance. But, CIF is a completely different beast. In a CIF contract, the contract is actually performed when the seller delivers the shipping documents to the buyer. It's not actually about the delivery of the physical goods themselves at that moment. It's all about the paper. So the real takeaway here is that a CIF seller has a very strict, very specific paperwork checklist. To successfully fulfill a CIF contract, the seller has got to ship the exact right goods, secure the sea carriage, arrange a solid marine insurance policy for the benefit of the buyer, prepare the invoice, and then tender all of these documents, the bill of lading, the insurance, the invoice, to the buyer within a reasonable time frame. By handing over these documents, the seller is basically guaranteeing that the buyer can either go claim their goods when the ship arrives or, worst case scenario, recover their financial loss from the insurance company if the goods end up at the bottom of the ocean. All right, Section 3, financing global transactions. Okay, so we've got the goods on the ship, but how on earth does a seller actually get paid safely when they are dealing with a buyer who is literally thousands of miles away? Let's take a look at how the banking system steps in to build this really brilliant chain of trust. This whole process is governed by the International Chamber of Commerce's uniform rules for the collection of commercial papers. Basically, the seller hands their shipping documents over to their local bank, which we call the remitting bank. That bank then passes those documents to a bank over in the buyer's country, known as the collecting bank. The collecting bank holds on to these incredibly important documents and says to the buyer, hey, we have your documents, pay up to accept them. And they will absolutely not release those documents to the buyer unless they pay up in full, or at least secure a trust receipt loan. No money, no documents. And without those documents, there is no way the buyer can legally obtain the goods from the ship. It's an amazing system. Now, if you're a seller and you want an even stronger, almost ironclad guarantee, you're going to use letters of credit, also known as documentary credit. Here, the buyer actually instructs their own bank, the issuing bank, to pay the seller directly. The buyer specifies exactly which documents the seller has to deliver and sets a strict expiration date. If the seller produces those exact documents before the clock runs out, the bank is legally obligated to pay.
It creates just incredible security for everyone involved. And these can come in several different flavors. They can be revocable, irrevocable, confirmed, unconfirmed, or even transferable, totally depending on what the specific deal needs.
Time to head out onto the water with Section 4, Navigating Carriage by Sea.
So the money is all sorted out, safely locked away in the banking system. Let's actually explore the physical journey of the cargo over the water. Moving massive amounts of goods by ocean relies on something called a contract of affreightment. Specifically, we are looking at a charter party. This is a contract where a ship owner, the carrier, hires out the whole thing or a really substantial part of their ship to a charterer just to move goods from port A to port B. Legally speaking, all of this falls squarely under the Carriage of Goods by Sea Act of 1982, which itself actually incorporates the famous Brussels Convention on Maritime Law. If you find yourself needing to hire a colossal cargo ship, you basically have three distinct options. You can grab a voyage charter, which means you're hiring the ship just for one specific trip. You could get a time charter, where you hire the ship for a set block of time. Or, and this is fascinating, you can choose a charter by demise, which is often called a bare boat charter. This is where you obtain total possession and control of an empty ship. You literally have to supply your very own employees to act as the master and the crew. You get the whole shebang. Now, when you sign one of these charter parties, you are going to bump into some pretty heavy traditional maritime legal clauses. For instance, there's always an implied term of seaworthiness. You'll see a ship owner's lien, which allows the owner to literally hold on to your goods until your freight charges are paid. There's the Caesar clause, stating that the charterer's liability completely ceases the second the goods are loaded. You've got expected perils that excuse the ship owner from certain uncontrollable risks. But you really need to pay close attention to lay days. These are the allowed days for loading and unloading, because if you're the charterer and you don't finish loading within these lay days, you become liable to pay some serious damages to the ship owner. In maritime law, we call these costly delay damages demurrage. And look, if a major disagreement arises over any of these complex clauses, these international contracts usually completely bypass traditional courtrooms. Instead, they rely on specific dispute resolution mechanisms like arbitration, mediation, conciliation, or ombudsman schemes to settle things quickly and privately.
This brings us nicely to Section 5, Essential Shipping Paperwork.
Okay, the ship is loaded, the cargo is on its way. We have arrived at the absolute most important document in this entire global process, the Bill of Lading, or the BOL. This thing is signed by the ship owner or their agent and handed directly to the shipper. It brilliantly illustrates a core concept of global trade because this single piece of paper does double duty. First, it sets out the actual legal terms of the contract for the carriage of the goods. And second, it acts as a legally binding receipt stating that those specific goods have indeed been received for shipment. Ultimately, possessing this one piece of paper is the literal key to legally obtaining your physical goods at the destination port. Of course, you absolutely want to make sure you have the right type of BOL. For example, a clean BOL means the goods appeared to be in perfect condition when they were loaded. A claused BOL officially notes any defects or damages right there on the paper. They can also be negotiable, meaning the ownership of the goods can actually be signed over and sold to someone else mid-journey, or non-negotiable.
And finally, Section 6, Taking to the Skies.
Let's briefly shift our focus away from the slow, heavy ocean vessels and look at fast-paced air transport for our final mode of international carriage. Now, carriage by air doesn't use maritime law at all. It relies on its own historic international rules, specifically the Warsaw Convention of 1929 and the Hague Protocol of 1955. It uses very specific paperwork to keep things moving lightning fast and completely legally. For us humans, it's the passenger ticket. For our luggage, it's the baggage track. But for global trade, the absolutely crucial document is the airway bill or consignment note. And there's a fun twist here. Unlike a bill of lading, which is created by the ship owner, an airway bill is actually created by the consignor, the person sending the goods, and then delivered to the carrier.
So what does all of this mean for you? We've covered Incoterms, FOB, CIF, letters of credit, dispute resolution, and bills of lading. I know it sounds like a lot of dense legal jargon, but these are literally the invisible gears turning our modern life. Next time you buy an imported product, whether it's a brand new smartphone or a heavy piece of machinery, I really hope you take just a second to picture the brilliant, century-old frameworks of trust, banking, and maritime law that all worked perfectly together to bring it safely right to your door. Thank you so much for joining me for this explainer. I hope you walk away today with a completely new perspective on the machinery of the global economy.